Okay, good afternoon, everyone. Welcome to this webinar by 42 Bedford Row. For those of you who don't know me, my name is Michael Salter. I'm a member of Chambers and I sit as a fee-paid employment judge in England and Wales and hold a similar position over in Jersey. Now we've got quite a large number of people who have signed up for today. So I'm just going to give Zoom a couple of minutes to do its thing and admit as many people as it can before we start the webinar in earnest. So whilst we're waiting, for those of you who don't know, this is part of Chambers' series of free webinars. Recently, Jason Breyer and Kath Urquhart provided a very useful and interesting webinar on privilege. Jill Crew and Nick Bidnall-Edwards presented one on whistleblowing. Susan Chan and Andrew Carter discussed anonymity and restricted reporting orders. And Nick Singer did a talk about how to go around assisting barristers when preparing claims and getting the case shipshape. All of those, if any of them are interesting for you, all of them can be viewed on Chambers' YouTube channel, and the recording from today will go up on the YouTube channel and Chambers' website probably tomorrow. I say it's part of a series of webinars. We have another one in May as well, so keep an eye out for the details of that when they're released. Now, today's webinar is something of an odd one. It's an opportunity for me, hopefully, to highlight what I see and what drives me mad when it comes to witness statements. It's almost like a therapy session, I guess, for me, but it's a lot cheaper, I suspect, than me having to pay someone to listen to me as I lie on a couch. So I can see that the numbers of attendees are slowing down. So let's get cracking with the presentation proper. Now, there I am. I'm sure we're all aware of this over the last couple of years and the growth of webinars. If there are any technical issues, reset your computer, turn it off, turn it back on again, and that usually resolves any of the issues. It's not going to be a death by PowerPoint. Hopefully you've all received the handout that has the slides that I'll be referring to and the references to the various studies and case law and such like. So hopefully I think there's only one particularly text heavy slide that you've seen in the handout. There will be time for questions at the end. However, if you have a question during the session, please type it into the Q&A box at the bottom, not the chat function. I think the Q&A has a bit more functionality, and I will come and answer them when I see them, or as I say, towards the end. So thinking about what we're going to cover over the next 40 or so minutes, I'm going to talk about some common failings I see in witness statements, talking about how to maximize the impact on statements, and also give some practical tips as to how to physically go about presenting statements. Now, I'm only talking from my personal point of view. I'm not here as a delegation from the Employment Tribunal judiciary. It is simply my views, and you may disagree with them. You may take some points from here and hopefully deploy them for the benefit of your clients. So what makes a good witness statement? For me, a good witness statement is like this man's food blending skills. If it's good, you won't even notice it. It will just happen. You'll have read it and you put it aside, and you won't even know you've read a witness statement because it just imparts effortlessly the knowledge. This man's blending skills, he's blending that orange thing, whatever it may be, and is perfectly fine. If, however, it's bad, it's going to leave a mess. It's going to leave a mess that can't be cleaned up for a long, long time, and you're finding bits of it lying around the place when you thought you've finally dealt with it. A bad witness statement will make you angry, and it's only the bad ones that you tend to remember. Let's say the good ones, they just slide into your consciousness and slide out the other side, and they leave the information that you want them to. So what makes a good witness statement? What guidance do we have? Well, there's actually very little guidance out there. The Citizens Advice Bureau have a very helpful guide that they produce on tribunals generally, and it says that a witness statement is an important document and you should take care when you write it. The most important evidence in your case is the evidence that you yourself give. The tribunal will not allow you to add anything or change your evidence once the witness statements have been exchanged, unless there is a very good reason. So it's important to get your statement right. Equally of interest, recently, Birkbeck University conducted a study particularly aimed at witness statements in the employment tribunal, and I'll be coming back onto that and referring to it in a couple of the later slides. The tribunal rules have very little in them addressing witness statements. Rule 43 says that the witness statements will be the evidence in chief. Rule 44 deals with the right to inspect witness statements, so you bring an extra copy for members of the public or press to be able to inspect in the tribunal rules. And then Rule 50 and Rule 94 deal with privacy and national security. Again, I plug my colleague Susan and Andrew's webinar on privacy and national security. There are also 2 presidential guidances giving general advice. The General Case Management Presidential Guidance, Guidance Note 3, paragraphs 10 and 15 give very general advice, as does the presidential guidance on vulnerable parties. And to be honest, it provides nothing more really than general assistance, i.e. Witness statements should be typed in chronologically numbered paragraphs. Interestingly, by a bit of a way of an aside, the Birkbeck study challenges the assumption that in the presidential guidance that a chronological order of witnesses of a witness statement is best. Now, personally, having dealt with thematic witness statements and thematic bundles over the years, I'm definitely on the side of the president in this one, that having something set out chronologically tends to be, in the vast majority of cases, tends to be the better option, in my opinion. Now, I sit on the Southwest region, and we have a standard paragraph that we put into our orders that I think gives a bit more of a steer as to how I personally like witness statements to be structured. And that paragraph says that witness statements must be full, must not be repetitive. They must set out all the facts about which a witness intends to tell the tribunal, relevant to the issues to be determined at the hearing, that are identified below, including the factors relevant to any time limit issues. They must not include generalizations, arguments, hypotheses, or irrelevant material. And I think here we find the key as to what makes a very good witness statement. And for me, it is following the list of issues. If you've had the misfortune or fortune, shall we look at it, of attending one of my talks on case management, you know the importance that I personally place in a list of issues, and won't go into any detail about it here, but in short, a good list of issues makes the management of a case a lot easier and a lot more efficient for everyone. So what is the aim of a witness statement? Again, I like to look at tribunal litigation as having 3 phases. The first stage is from the pleadings to the case management hearing, and here the pleadings, ET1 and ET3, are the core documents, are the key documents that you need to focus on and make sure you get right. Stage 2 is from the case management hearing to exchange of witness statements. Here, again, as I've touched on a few moments ago, list of issues are the key documents for me. They dictate the scope of the bundle, the scope of the disclosure exercise, the relevance of witnesses. So I cover that in my talk on case management hearings. Stage 3 is about the exchange of it's from the exchange of witness statements to the end of any remedy hearing, and here the documents are key. Notice I didn't say the witness statements are key. The documents, I think, are what is key at stage 3 of the final hearing. The aim of the statement is to contextualize those documents, to fill in the gaps and give some physical form to what is etheriae, the motivation of the manager for doing what they did, or the to lay out in words what was going through the mind of the person that made the decision to dismiss or not to promote, or whatever the act of discrimination or the dismissal claims all about. Now, if the art of advocacy is to make the job easier for the judge, the witness statement is your mechanism for distilling the complexities of real life into a short, readable document, and it's no easy thing. It's more complicated also by the fallibility of human memory. At the beginning of the month, the Guardian newspaper ran an article about a report from the University of Amsterdam, and your handout, I think, has I think it's +1 is the journal. And in that, the university, and it can, I tried to read it, it's about 40 or 50 pages long and has some very, very long words in. But basically, the University of Amsterdam found that human memory degrades after a couple of seconds. One of the quotes that really stood out for me was that they say that when we have, particularly when we have strong expectations about how the world should be, when our memory starts to fade a little bit, even after 1.5 seconds, 2 seconds, 3 seconds, then we start filling in that degradation with our expectations. And the biggest effect the study found was on speech, and the details of this being replaced by general meanings rather than the specific words and intonation that was actually used. And that's terrifying if we think about it. If we think that even with the short time frames to present a claim, so witnesses will be aware that the claim has arisen within 3 months plus whatever time spent in ACAS. If human memory is already started to degrade within moments of the incident occurring, the capacity for a witness to be honest and to genuinely hold beliefs but be wrong, just it's terrifying. And we've got to, I personally do wonder what the utility of quite a lot of witness statements are that just go into all sorts of unnecessary detail and don't address the documents and just give a general stream of consciousness. The impact and the capacity, I think, for witnesses to be frankly just wrong is going to be huge when we think that 5-day cases are now well into the third quarter of 2024 in some regions. That said, if you're blessed with a witness who has perfect recall, fantastic. But be aware, there's a fantastic case in 2017 that it's a High Court case called Patel and Patel, involving a forged will in a long-standing family dispute. And Mr. Justice Simmons, having heard the evidence of various witnesses as he found implausible, commented, "The degree of minute detail which they purported to remember about events of June 2005, 12 years earlier, was, to my mind, quite incredible. Each witness, number 1, number 2, and number 3, were giving evidence about an event that supposedly occurred 10 years before, that they were asked to provide 10 years before they were asked to provide a witness statement. And it was an event of no personal significance to any of them. In these circumstances, I would have expected the witness to have at least a vague and outline recollection of what occurred, yet one or more of them purported to remember exactly who stood or sat where in the office, what day of the week it was, who drank tea and who didn't, and when, which pen each of them used to sign, and what the deceased did with her pen after signing. Witness 2 was supposedly asked witness 3 the date and was told this, but neither of them could put that in their witness statements. And they also could remember what colour dress the deceased was wearing and what the deceased had to eat after the shopping trip. This did not, in my judgment, have the ring of truth. One might think that the learned judge was being slightly diplomatic with their criticisms of the statements in that case. Now, concerns over witness evidence in commercial cases are not new. And I'm going to sound a bit like one of those very cheesy theatre reviews. If you only see one play this year, make sure it's this one. Same with Guestman. If you're interested in limits on human memory and witness statements in commercial cases, and you only read one case this year, read Guestman. Paragraph 22 is where Mr. Justice, or then Mr. Justice Leggett, sums up his concerns, but in the 5 or so paragraphs leading up to 22, he really breaks it down into some very telling points. But I think it does it's useful to have a quick read of Guestman, and just, as I say, just forgive me as I look off to where I've got the screen. The best approach for a judge to adopt in the trial in a commercial case is, in my view, to place little, if any, reliance at all on the witness's recollections of what was said in meetings and conversations, and to base those factual findings on inferences drawn from the documentary evidence and known or probable facts. This does not mean that oral testimony serves no useful purpose, though its utility is often disproportionate to its length. But its value lies largely, as I see it, in the opportunity which cross-examination affords to subject the documentary records to critical scrutiny and to gauge the personality, motivations, and working practices of a witness, rather than in testimony of what the witness recalls of particular conversations and events. Above all, it is important to avoid a fallacy of supposing that because a witness has confidence in his or her recollection and is honest, evidence based on that recollection provides any reliable guide to the truth. So with those words ringing in our ears, you do kind of wonder what the purpose of a witness statement really is. And as I've alluded to earlier, I think it's really is to be a helpful and friendly guide that directs the reader to the salient points in the witness in the bundle and in the list of issues, and does so in a way that engages the reader and doesn't throw up barriers. Now, there are always going to be two barriers, and as a quick aside here, it strikes me there's always going to be two struggles that us as lawyers face and require careful management. There are claimants who need to understand that not everything over their entire working life is relevant to the issues that the tribunal are going to determine. And again, so a clear list of issues nails down what's relevant, what isn't. Respondents, potentially you have the other extreme, that respondents have too little involvement. They'll wave you off and ask you to write the witness statement for them, and it's only when they are being cross-examined as to the contents of the statements that internally they may wish that they have spent a bit more time on. So who is this guide for? If the witness statement is going to be a guide, who is the guide going to be for? Well, it's going to be for the witness themselves. This is the high point of their evidence. Rarely does evidence get better in cross-examination. It may not get much worse, but it rarely gets better. And a witness statement gives the witness, who's alone in the witness box with 1 or 3 people staring at them, literally judging them as to what they've done, it gives them a rock to cling to. It gives them some sort of comfort. The danger is if it gives them too much comfort, and every question they are asked comes with the answer, I remember I wrote something about this in my statement, flick, 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 as they then try and find it in the relevant paragraph and then read that out. So there is a danger that your statements, if they, particularly with respondent witnesses, won't get the witness to engage with the case, because if you've written it for them, there's a real problem in the getting buy-in. And so I repeat what Mr. Justice Leggett said, that confidence in their recollection does not necessarily mean accuracy. Probably the bigger guide, or the biggest value of a witness statement as a guide, is for the tribunal. It's easier for the tribunal to, or the easier it is, should I say, for the tribunal to find the evidence of your witness on a particular point, the better it is for your client. using the list of issues as a framework, it will ensure that there are no gaps. Too often, I've seen witness statements on discrimination claims where liability and remedy will be addressed, and there's simply nothing on remedy. There's simply nothing about injury to feelings. And on unfair dismissal statements, quite often there's very little about remedy. But I think the major omission in my experience has been for discrimination claims, that if they don't follow the list of issues, or don't even at a covert level follow the list of issues, gaps appear. Also, there are risks that if you don't follow the list, there are going to be irrelevancies creeping in. There are accounts I've heard of employment judges asking representatives to justify each and every paragraph of witness statements, and asking which of these paragraphs relates to paragraph 6 of the list of issues, for instance. So if you have that in mind and use the list of issues as a framework, you can reduce those awkward moments if you are asked those sorts of questions. And kind of dovetails into the third use of a witness statement as a guide. It's a guide for you. You can signpost the relevant part of the statement, start with the list of issues, put that onto your blank page or your witness statement precedent, and build your statement from there. I find when I'm doing that, it imposes a structure and is a good discipline, ensuring that relevant evidence is there. And it's an awful lot easier than writing the witness statement out and then trying to put in the list of issues and say what, or the paragraphs on the list of issues and say what it goes to and what it doesn't. Also, in the larger case, you have a nice pre-exchange checklist. You can contrast your witness statement with the list of issues and literally just tick them off. The contents of the statement equally are as important, obviously, as a structure. Just give evidence. It's not an opinion. It's not an argument. I did a case recently where the entire statement, which was written by a professional advisor, pretty much started every single paragraph with the words, "The claimant will say, blah, blah, blah," but never actually told me what the claimant was saying that she would say the respondent's heinous and egregious breaches of the ACAS policy, but didn't actually say what they were, and only had one reference to a page in its 10 pages. It fundamentally missed the point that the witness statement was to take me to the evidence and show where the failings were. And it posed a barrier. It posed a barrier to my reading in of the case. So 2 key points I think to take from here are know your audience and know your witness. With those 2 factors in mind, I think you'll be in a much better position. In the Birkbeck study, this is know your audience. In the Birkbeck study, which I should say interviewed judges, panel members, litigants in person, others involved in tribunal service, professional representatives, and it's got some very useful insights, and it's only 10 or 15 pages and doesn't contain too many very long words, so I found that relatively easy to read. But one of the quotes from the judge, who I think is a really good starting point, is that imagine that you are telling the story to a reasonably bright 12-year-old who knows nothing about it. And that was their starting point for a witness statement. Now, those of you who use AI, ChatGPT can do this if you prompt it correctly. So I'm going to be totally honest and upfront about this. I was dealing with a case where one paragraph from a witness statement didn't make very much sense to me. It was all quite technical. So I paraphrased it into ChatGPT and with the prompt, explain this to a 5th grader. And it came back and I was just about able to understand it. So probably an endorsement to ChatGPT as opposed to me. But going back from getting out of that rabbit hole, know your audience. Are you judge sitting alone, or are you before a full panel? Judge sitting alone cases tend to be much more of the document focused cases, unfair dismissals and contracts and wages claims. And so probably fall more within the guestmin realm of what's the purpose of the witness statement, to just explain the documents. 3-person panels, so PEDA, detriments, discrimination and like, tend to be more focused on the motivations of people. So I think the tribunal process has 3 phases. Oh, I see my camera's gone off. Just give me a moment. Don't know what happened there. Sorry about that. There tend to be 3 factors to bear in mind. Firstly, the new mandatory ADR rules. Some regions have it that if your case is over a certain length of time, the Southwest, I think it's 6 days, then you will go through mandatory ADR. And you will produce, and that takes place after witness statements are exchanged. There's a lot of front loading of work, so witness statements will exchange quite quickly. You then have a small bundle of documents, only about 30 to 50 pages, on top of the witness statements, which the judge who conducts the ADR will read. So there's quite a lot of heavy lifting that the witness statements have to do in a mandatory ADR type case. And then it's going to be interesting because most cases are over 6 days, are likely to be the non-guestmin type cases where you are looking at motivations of people. So I think there's going to have to be a real balancing act on those sorts of matters. The second factor that I think should limit or should influence how you draft your witness statements is we've returned now to the realm of delivery of papers on the day of the hearing. With COVID, prior to COVID, documents are delivered days in advance or and such like. And over that period of time, I was, and beforehand actually, in fairness, I was amazed at the level of reading in that the non-legal members do. That it's a real credit to them that when they were getting witness statements days in advance, they'd read the witness statements, they'd read the bundle, and when they turned up at 9 o'clock for our 10 o'clock start, we were able to have a meaningful discussion. Returning to delivery of papers on the day means that the reading in time for the panel members is obviously limited to whatever time the clerk comes to collect the papers and whatever time the hearings start. So the pressure here is to provide a roadmap for tribunals when they're doing their job on the day. Third, and I think the final factor to bear in mind is at the other end of the hearing. When you've got a reserved judgment, it may be days or even weeks before the tribunal get to meet again, find time to revisit the case and then deliberate and write the judgment. And I'm sure we all know how much easier returning to papers that you've read and prepared and put to one side are. And if you're anything like me, my handwritten notes are frankly atrocious. So anything you can do in a witness statement to assist the tribunal coming back to your coming back to your case after potentially weeks away doing other things is going to be incredibly useful. Know your witness should appear here. Here we go. Us as lawyers, we necessarily use quite flat language and quite measured language. And we seem to like to downplay the emotion of things. I don't know why that is. I don't see that there's anything wrong in an unfair dismissal case, for instance, for the decision manager, if this is their evidence, to say, I found it a difficult decision. I thought about it long and hard. It was someone I'd known for a number of years. Sean Jones, Casey, in his talk on witness statements from a number of years ago, calls it the serial killer paragraph. And it's aimed at showing the dismissing manager's experience, and basically boils down to, I've sacked hundreds of people over the years, and it just makes it sound like it's been done by some sort of robot killing machine, as opposed to a human being who has emotions and views and opinions and feelings. I think that a bit more humanity in witness statements, particularly when making difficult decisions, is not a bad thing to incorporate. Can go, or clients speak, as it were, can go to the other extreme. Quite a lot of industries have their own specific language, and you've got to find a way to be able to deal with that. I have a couple of clients who are repeat clients and have very specific languages and phrases that they use. And so my opening note for them has a glossary that I'm able to just cut out the phrases from these clients that don't appear. And so when the tribunal get the witness statements, they get a glossary of when you hear this term, it means this. And again, this is quite a telling point from the Birkbeck study that a barrister fed back, that because the witness's statements just didn't sound like him, it was quite easy for his opponent then to make submissions that really the witness statement wasn't to be relied on at all. I think it was a mistake to draft the witness statement as if the claimant remembered things as clearly as the witness statement suggested. The Mackenzie case and Rosenblatt solicitors, they're highlighted again this point in a High Court case, and it said that no witness statement was written using the witness's own words, and there were 4 witness statements that were the careful work of a legal team. Each statement works by making assertions about what happened as a level of generality or summary, rather than setting out the facts as recalled in detail, and resembles a position statement seeking to advance a case more than a witness statement. The summary of what happened is often an exaggeration of what is shown by the documents, or just inaccurate. It was evidence that the witness could not in fact recall what they stated in their statement, or where what was stated in the statement was contradicted in cross-examination, or was shown to be an untenable interpretation of the document. I'm left as a result with real doubt about the reliability of the contents of the statements. So how can you reduce this sort of risk? Well, get to your witness early. The other side may approach them and start contaminating their recollections. Talk to the let the witness talk first, and then try and hone in on what they are saying using open questions. Then go around and rearrange the thoughts into a chronological order. And as I say, think like a 12-year-old. Does this make sense? Does this statement, or will this statement assist 3 people sat in a room at 9 o'clock on a Monday morning understand the case that they're going to be dealing with over the next 5 days? There is an extreme example of not knowing who your witness is, and it's found in a criminal case. The CPS clearly were pressing for a witness statement to be provided from someone present at the scene, and a very important person. They chased and they captured the ne'er-do-well. Their name was on the file, and yet they hadn't provided a statement. The police pushed back and said, well, you're not going to get a statement from this person, it's just not coming. And so it went on and on and on, and obviously some senior bod at the CPS contacted a senior police officer, who marched downstairs and thumped the desk and said, right, I need a witness statement from Peach. And this is the witness statement that Peach produced. It says, PC Peach, age if under 18, 4, signature is a paw print. I chase him, I bite him, bad man, he tasty, good boy Peach. Now, I don't think you're ever going to get to the stage where you suddenly realize your witness is a 4-year-old, I presume, German Shepherd dog, but it can happen to those on the thin blue line and those advising them. So please do understand your witness. Also remember that what has been seen cannot be unseen. Tribunals are human. At a subconscious level, they will ultimately end up liking one side more than the other. Make sure you do everything that you can do to make that you. If you have three people sat in a room trying to decipher a witness statement because it uses vague or technical language, that's not a good thing. People start reacting and feeding off each other's displeasure. And the more resistance points you build up, the harder it is for you to be liked. And the damage is done. By the time the hearing starts, and before there's supplemental questions or corrections or questions correcting errors, at a subconscious level, there has certainly been some impact on your client, who undoubtedly is scared and worried and nervous about what's going to happen. Also, the length of witness statements has an impact. In the Southwest, we restrict witness statements to a defined word count, and we require parties to comply with that. One of the quotes from the Birkbeck study came from a panel member and said, you know, the claimant's witness statement can run to hundreds and hundreds of paragraphs. What are the really important things? Now, that's our job as a tribunal. I get that, but it doesn't make life any easier if there's whole massive information and history there, some of which is perhaps not relevant to the case. Sorting through that sometimes can take quite a lot of time. There's some authority for the concerns of the tribunal. Now, this, let me remove my photograph. There we go. That is the coat of arms of Scotland and the Scottish judiciary. So we're going to go north of the border. And as many of you, probably all of you already know, historically, Scotland hadn't used witness statements. They didn't exchange witness statements. New presidential guidance came out in August of last year, so up to date, and heralded a new age where witness statements were acknowledged by the Scottish employment tribunals, and it gave 10 or so general points, and many of which are quite obvious to us with our experience. But numbered pages, numbered paragraphs, double spaced or space 1.5. Why? My point of view, I like writing over witness statements. Similarly, next point was single-sided. Again, I like to write page references or questions I want to come back to. Make them typed or legible, obvious. A margin of 3 centimetres. Interestingly, the Scottish practice direction said bold headings to assist the tribunal. Said arrange chronologically, use standardized abbreviations, and be specific in references. For the avoidance of doubt, the ability of the tribunal to deal with a case in accordance with the overriding objective will be hampered where reference is made in general terms to significant numbers of pages of documents in connection with a particular assertion. An example would be see page 835 to page 2077. I add one more to that. One more criteria is font size. One of the judges who reported back to Birkbeck said that one of his colleagues, now retired, said to a litigant person many years ago, I want you to set out your witness statement in no more than 3 pages. The litigant did that, but it was in a font size that this judge, quote, didn't know existed. It was minute. You needed a magnifying glass to read it. And this judge then says they don't tend to fix word limits. High Court case in your handout on Mansion Place and Fox Industrial Services. Obviously, civil courts, everything's a bit more formal in what is required of witness statements, but should contain, the judge in Mansion House said, should contain evidence the maker would be allowed to give orally. Cover those issues, but only those issues which the party relying on the statements wants the witness to cover in chief, not to provide a commentary on documents in the trial bundle, not to set out quotations from documents in the bundle, not to engage in matters of argument, not to deal with other matters merely because they may arise in the course of trial, not to include opinion evidence except where it's necessary as part of the witness's factual account. But this, I think, is the important point. The rules are not rigid statutes, and circumstances may dictate they're relaxed in order to achieve the overriding objective of dealing with cases justly. And that obviously bleeds into what we need to do in the Employment Tribunal, focus on the overriding objective. Kath Urquhart, one of the members of Chambers, used to be a journalist and had the misfortune of being my pupil. And one of the many things that I learned from her was the trick of thinking like a journalist. Journalists are taught to answer the following questions: who, what, when, where, how, and perhaps most importantly, why. So if in doubt, approach each of your potential witnesses with those questions in your mind. And I don't think you'll go too wrong with content of the statement. And say, if you think a list of issues is a useful structure, then you will have a useful structure on which to hang that content. So now we're looking at presentation. A couple of tips just on physical presentation. I like an introduction that says who the person is, what role they played, and what issues they're going to address. If you're going to put them into a bundle, and I commend that to you, if you're going to put them into a bundle, put them in the bundle in the order you intend to call that person. And put after their name what their role was. So you'll say page 1, witness statement, Fred Bloggs, investigation manager. One thing not to do is don't staple the witness statements you put in a file. There is a special place in Michael Salter hell for people who do that. It takes only a couple of moments to resolve it, but it gets my back up. So yeah, that's that. I told you it's a therapy session. If you don't put them in a bundle, say in the opening paragraph, make sure, or if you have an opening note or anything like that, make sure in there you say what the person is, or who the person, what role they are, and how, when you intend to call them. Because nothing angers me more than Staples, obviously, but apart from Staples, coming close second behind Staples, is that nothing angers me more than reading the first page and a half of a witness statement to find that this person was the 3rd level appeal manager and we haven't dealt with the investigation yet. So make it quite clear, early doors, quite obvious what this who this person is, what issues they address, and say that those are the Michael Salter bugbears of the physical presentation of witness statements. Now, I think we've got a curious owl as our next slide, which we do, which indicates to me it is question time. So I've got some questions. Anonymous attendee says, how do we receive the handout? Should have been emailed to you today. I will make sure that when the link is sent out with the recording, that there's another copy of the handout. Chloe says, I have always used witness statements to guide through the bundle, so letter sent at page X, this is why. Is it best just to focus on the list of issues and not reference the documents, or to guide through the documents in the bundle? The issues don't live in a vacuum. They've got to be put into some sort of context. So I don't want anyone to take away that your witness statement should just be, here's a list of issues, here's what we say in relation to them. Contextualize it. I think you're well on the right track there, Chloe, with explaining, if your witness is the investigations manager, how they came to have the investigation meeting. Hannah, if liability and remedy are being heard separately, do the witness statements still need to address remedy, or can those be dealt with a separate hearing? I'm always one for doing the minimum amount of work. So I would, if there's going to be a separate remedies hearing, chances are at the end of the liability hearing, there will be directions given for evidence on remedy and witness statements on remedy. So I would work on the basis that they're separate, unless the hearing was originally listed to deal with both, but because of time problems, can only deal with one. Afterwards, could please study. Yep, Anita, that's not a problem whatsoever. I will arrange for that to be sent out with the email. Anonymous, what is the word count you limit witness statements to? All really depends on the case, and the number of issues. Often, particularly when it's a case where it's a claimant by themselves, we will say, often we work on the theory there are 500 words per page. So you kind of lick your finger and hold it up to the wind a little bit and say, well, this is an unfair dismissal. So probably the claimant could do 3,000 words, so 6 pages. And then we totalize those for the respondents and say, you will have X thousand words in total across your however many witnesses they intend to call. Lucy, how do you deal with evidence which weakens your overall case? Head on, but yes, definitely play everything with a straight bat. If there is evidence that is less than helpful in your witness statement, I think you've got to deal with it, particularly if it's one of the issues that has been highlighted at the case management hearing, because we've all seen tribunal judgments where it comes to the judgment after the recitation of the facts and the law. Usually they structure that around the list of issues, and if you haven't addressed that, it does look bad when it's only coming out in cross-examination of your witness. Ron asks, do you think that it's a good start to follow the particulars of claim as well, or grounds of resistance, or should this be avoided? For me, by the time you've got to drafting a witness statement, the pleadings take a much lesser role, and I say that because hopefully you'd have had a case management hearing at which a decent list of issues has been identified. The list of issues is the result of an analysis of the claim form, the claims that have been presented in there, the factual background to the claims, and then what the respondent says in its response. So hopefully you've been able to distill down what are the relevant points and what are the controversial points that the tribunal needs to determine. So I think that should be the focus. If you haven't had a case management hearing and you're not able to identify a list of issues with your opponent, then I think unfortunately you're going to have to do as best you can, and if worse comes to worse, just go back to the primary sources, go back to the statute, say for a direct discrimination claim, you need to show what the protected characteristic was, what less favourable treatment was that a detriment? If so, was it because of the protected characteristic? And that structure will assist, I think, with witness evidence. Anonymous attendee, what are your thoughts on witnesses expressing opinions, e.g., I was of the view he wasn't a competent employee? Opinion is admissible. It's admissible as a shorthand of facts that they perceive. So if this manager says, I don't think Mr. Bloggs was a competent employee, that's their opinion. But just take it one step further. Why do they say he wasn't a competent employee? Mr. Bloggs was not competent because he was always missing targets. He couldn't use the computer system, those sorts of things. I don't think there's any problem on opinion when it's backed up by an underlying strata of facts. On anonymous attendee, on a practical side, if witness statements are to be exchanged simultaneously and one party intentionally delays in exchanging this statement until receipt of the other party's statement. Wow. Okay. how should that part exchange respond? Well, you can bang your fists on the table with the tribunal, and hopefully that will be put before the judge on the morning, or even better, beforehand. What I find, if there is a delay and you're on the side of right, you've got your witness statements available, I exchange them but password protect them, and say you'll get the password when you have sent your witness statements to us. That way you can't be criticized for delaying exchange of statements, and it clearly puts the emphasis onto the other side. Eve Montaz asked for the link to the Birkbeck study. Yep, I'll get that. That's not a problem whatsoever. Anonymous NTND, how do you feel about the witness statement cross-referring to replies to particulars? I have a very complex discrimination case with tight word count, and thus have cross-referred the claimant's replies on some issues. Yeah, the replies aren't evidence. So you need to find a way to make them evidence. If there's an account in the replies, I don't know. Obviously, don't know. Excuse me. Excuse me. I don't know the details. But if there's a replies, you need to find some way of getting those inconsistencies in as evidence. So you might say, I wouldn't see too much of a problem with saying, I note the claimant's reply on this. I would say, and here's my evidence in response. It seems to me to be very similar to the use of a list of issues. Teresa asks, where the other party has added lots of irrelevant information, would you just ignore this, even if these points have been made with a view to affecting the credibility of a witness? Yes, I think I would. My approach is to focus on what is relevant, have instructions for the most important of the irrelevancies, but you don't want to burden the tribunal with having to engage in wrestling with irrelevancies. It requires some quite robust advice to your clients, particularly if allegations are being made about them that they're not happy and they're very sensitive to. But if it's irrelevant, say it's irrelevant, and potentially even address it with the tribunal at the outset, saying, Judge, you'll see paragraph 826 of this statement says this. We don't see this as relevant. We're not going to deal with it. And then if the tribunal want you to address it, they should raise it with you, particularly if they particularly if they take a different view to you that it is not irrelevant. Now I see I had a pop up, but not in the Q&A. So let me have a look. Oh, we've got 62 entries in the chat. Yeah. Yeah, quite a lot of questions in the chat. Okay. Being directed back to the Q&A. Let me just see if I can take a couple up. If you discover a small error in the witness statement after exchange, how best should this be handled? Supplemental examination, that's from Joel. Supplemental examination in chief. And if the other side are represented, raise it with them in correspondence or in the morning, say that you'd have read paragraph 6, you see it's incorrect. Quite often there are typos or dates that are wrong in witness statements. I don't think I've yet to see very many trials where all the witness statements are perfect. And again, the Birkbeck study, one of the judges in there gave something to, used to tell witnesses that don't worry, solicitors always leave a deliberate error in the witness statements on a date or a page reference, so just to break you in easy. So I wouldn't worry too much if there is a slight problem. How do you handle witnesses who go off on how do you handle witnesses who go off on tangents? You obviously can't tell your witness in advance what their evidence should be, but I think there's real utility in saying to them and just giving them general advice, which will be answer the question you are asked. If it can be fairly answered with a yes or a no, do that. However, do not feel afraid to add to it if a full and fair answer requires detail. I try always to have a pre-hearing meeting with my witnesses, either via Zoom or we get to tribunal nice and early on the day, and I run through this, because it does infuriate panel members and judges when we're trying to take a note of what's being said, and it's a stream of consciousness on matters that aren't relevant. So I think I've answered all the questions. Oh, another question may have just snuck in. No, it hasn't. Okay, well, thank you all very much for attending today. I hope we've covered points that you found interesting or useful, doing the structure and the aim of a witness statement. And I would, oh, sorry, 2 new messages just arrived. I would thank you all. And obviously, if there is any follow-up that you would like, please don't hesitate to send me an email or give me a call in chambers. More than happy to discuss matters with anyone. Let's say when you get the handout, my email address is on the bottom of the slides, and I think on the handout itself. So thank you all very much for attending, and I wish you all a very happy evening.